All right. Here we go. In 3, 2. Well, welcome into New York's Asset Protection Roundtable, a 3 pillars of protection program with attorney and counselor at law Ted Alatsis. I am Ben George, and we're glad to have you back into this episode. We're going to talk about beneficiary designations quite a bit on this episode and why they are not the answer to estate planning. While they do fill some gaps and do help you out in some aspects, it does not complete an estate planning. There are a lot of holes and some other considerations that need to be taken into account when going through that. So that'll be the episode today. Ted, welcome in. How are you?
Doing great, Ben. Hope all's well with you.
It is. I know you just got back from a little trip. Did you enjoy some time away from the office?
Yes, it was relaxing, which was great. The weather was fantastic. Got to spend some time with my family, so it was a welcome opportunity.
Do you unplug completely when you're on vacation? Can you actually step away altogether?
No. I try the best I can, but in this virtual world that we're working in, somewhat there's the temptation and sometimes a need to deal with some things on a remote basis. So we had to do a couple of court appearances, for example, but otherwise, yeah, I tried to unplug as much as I could.
Very good. Well, glad you enjoyed some time off, and hopefully wherever you're listening, you've enjoyed some time off here recently. But today we got a good show for you, and I'll point you to the website too. So if you have any questions about estate planning or about what we discussed today, beneficiaries, just check out alatsaslawfirm.com. Again, ALATSAS lawfirm.com. There's a link there. You can also call the numbers on the website. Plenty of other resources there as well. But there's a big button in the front to schedule an appointment or consultation with Ted and his team there to kind of get that process moving. But today we're going to talk about beneficiaries, and there are many types of accounts that allow the owner to designate beneficiaries to receive the account after the owner dies. And that can be quick, it can be easy, and it oftentimes a no-cost way to pass on the account after someone dies. However, the ease of setting up beneficiary designations can trap some people into thinking that their estate plan is done. And it is one piece of the puzzle, but it is not the entire puzzle. So I want to kind of point out some areas that you're going to fall short with your estate plan if you rely solely on beneficiaries. So the first one, Ted, I want you to take us through are underage beneficiaries, because obviously there's a little more goes into it here, right?
Oh, absolutely. Having a beneficiary who's under the age of 18 it can be problematic, certainly when the beneficiary are supposed to get their money.
So what are some things you have to consider about, or what else do you have to add into an estate plan here? Because I guess, what if someone is, even say 10 or 10 years of age, and you've named them as a beneficiary? What all goes into that to pass that along? If that's what you have.
Yeah. So I mean, what happens in that scenario is, when the beneficiary is under the age of 18, bank is not going to be able to give their money to them. So what essentially happens is a custodian would have to be appointed to take care and manage those funds for them. So if they don't have a custodian or a guardian, which requires a legal proceeding, then that money just kind of stays there until they reach the age of 18. And that could be problematic, certainly, because when accounts are inactive, you have issues with the state. You have issues with the ability to draw from those funds, to use those funds if the beneficiary needs them. So there's a lot of complications that are unintended that can happen in a scenario like that, and certainly not necessarily a good idea.
Well, is it a good idea, even if, even talking about age 18, is it even a good idea to have a beneficiary who's 18 to leave them money directly at that age?
Well, I mean, at the end of the day, I think the conversation is about how much control you actually want to have, what kind of actual protection you want to have for your beneficiaries. Because when you do asset protection, for example, you're not necessarily just doing it for yourself, you're also doing it for your beneficiaries, right? So at the end of the day, if you designate someone as a beneficiary, they get it. If they're old enough, they get it, and there's no criteria for their getting it other than they're alive. And so if, for example, they are a spendthrift, they have, massive debts, they're about to get sued or something like that, that money is, ascertainable by their creditors. So you're giving someone a gift that may actually not be a gift, be more of a curse. So at the end of the day, you kind of have to think it through. So beneficiary designations aren't necessarily a good idea in most scenarios.
Okay. some things to think about there with underage beneficiaries. All right, let's talk about some unknown or some uncontrollable contingencies. Let's start off with, if you have a primary and that beneficiary is not alive, what happens to their share?
Okay, so it depends, right? So if you have a primary beneficiary without a secondary beneficiary designated, then what would essentially happen is that person's share would go to their estate, which requires probate, which was one of the reasons why you avoided doing a will in the first place, and you designated someone as a beneficiary. So that's one of those unintended consequences. Some banks, some financial institutions do not allow for beneficiary designations beyond the first designation. So there are, it does end up getting tied up in either probate or intestacy or administration proceeding, which requires the court to be involved, regardless of how big the estate is.
How long can that process take? I'm thinking just about like because a lot of times we set beneficiaries and just kind of forget it, right? You begin work, and
Mhm.
one of the first things you do when you make that contribution amount, you set up your beneficiaries. Hopefully, you put that in there right away. But let's say over time you worked for a while and you just haven't really thought to go back through there. And let's say you do have somebody in here that maybe passed away years ago. How difficult can that be to sort out?
Wow. So it depends a lot on how complicated the familial relationships are, right? Because in New York, the government has pretty much set up an estate plan for you if you don't realize it, and that's called the intestate distribution laws. If you don't have a will, you die in New York without without beneficiaries being designated, or you don't have a written plan, then New York has a hierarchy of familial relationships that will end up getting your assets. And if you have a child that you wanted to disinherit, or third cousin twice removed,
Mhm.
that you had no intention of ever giving them anything, they may end up getting that distribution. So um, it can be a very complicated process. The typical administration proceeding, 6 months in Kings County, where we are here in Brooklyn, to as much as 2 years. So it can be a very lengthy process, and one you could avoid, certainly.
Right. One other kind of uncontrollable contingency here is if you have a beneficiary that you've named, and you kind of touched on this in the first answer a little bit, but if they're going through hard times, right? They're going through divorce, a lawsuit, bankruptcy, there's no way to delay that payout or even protect that payout amount from just being lost, right?
That's right. And that's again one of those, you intend on giving a gift, but what you're really doing is creating a problem potentially in a scenario like that. And so, once it's given, and you can't really control it, you can't do anything about it. So um, that's why that's essentially the difference between planning and just doing things, right? Because if you plan, you can avoid a lot of these unintended consequences that may be detrimental to your beneficiaries. So yeah, it goes, similar to the example I gave earlier about, the spendthrift, the person who has judgments and has huge credit card debts or something like that, and can be subject to a lawsuit. If you name them as a beneficiary, that's something that those creditors can take. If you are careful and you plan accordingly, you could avoid that, and make sure that they get it in such a way so that the creditors don't get it.
All right. So that's another reason. Another consideration with beneficiaries here. Another one is it doesn't work for everything, right? There are a lot of assets that don't have beneficiary designations and some pretty big ones.
Yeah, absolutely. Like in New York, for example, there is no beneficiary designation. You can't do that for real property.
Okay.
So you have a house, you want to designate someone as a beneficiary, you can't do it. There are some states in the country that do it, but it's rare. And also, for the same reasons that we mentioned earlier, not a good idea. Cars, businesses, you can't really do that. Timeshares, for example, all of those things, you really can't have beneficiary designations. And then the personal property, right? So things that you have in your house, things that collections, things like that, you really can't name a beneficiary for those things. You have to kind of spell that out.
And that's so important because a lot of these are very, very expensive assets and very valuable, whether they be, monetarily or, emotionally with personal property. These are, very important assets in many cases. So you need to have a plan for them that beneficiaries will not cover. And then there's others that you mentioned that only allow maybe say one beneficiary, or just have a limited basis for beneficiaries that you need to have some contingencies for.
That's right.
All right, last thing here on the list is causes families to compromise their wishes, these beneficiaries. And it may not be appropriate to give outright inheritance distributions, but families do it anyway because it's the only option, right? So keeping their family in mind, I know that's a big part of the estate planning process, right? Is making things easier for your family so that you're not throwing them for a loop, or creating some kind of controversy or tension within the family.
That's right. That's right. And you're not, when you just do beneficiary designations, you really don't control any of that. And certainly, that's why planning is better than simply um, acting on a whim. You sit, you draft your documents to reflect the wishes that you want, to make sure that the beneficiaries who you want to receive your assets get them, and also to basically put everybody else on notice as to, these are my specific wishes, and I don't want anything else to happen other than what I've spelled out. And generally speaking, when people are forthright with that and they're able to spell that out, conflict is avoided. Um, and certainly it just makes it easier um, to make sure that who you want to get your things, get it.
Well, the beneficiaries obviously are important to have, and I'm sure that you work through this with your clients too, quite a bit. Ted, how do you go through the beneficiaries first meeting, first couple times you're sitting down with someone just to kind of see what they have laid out, and how often are you kind of going back and referencing those and just making sure they're updated?
So what we generally do is when a client first comes in, we have them fill out an intake form, and then we kind of get a sense of what their family structure is like and what their intentions are and what goals they have, right? So when we go through all that stuff with them, then at that point we start working with, coming up with a plan that fits their needs. And many times, there's an expression that there's a child who's either done more, or has it needs more, or perhaps has some financial needs above and beyond the norm. And then maybe there's another child that's significantly more successful, and so they want the person who's in our office is looking to give one child more than the other, etc. When we plan and we articulate these expressions in their documents, we make it clear what the rationale is, right? So there is no misunderstanding later as to why certain things were done a certain way. Um, and that's one of the benefits of planning. Um, you want to be able to protect potentially your children from a divorce and having their assets taken away in a divorce, or you want to protect them from lawsuits, or you want to protect them from money problems, or frankly the immaturity, right? They're really young and you don't want them to necessarily have everything all at once. With proper planning, you can do all that. You can accomplish all that. By simply designating people as beneficiaries, you lose all that flexibility and lose all that control. So when we sit down with our clients, we go through all that with them. We make sure that their wishes are what they've articulated, reaffirm that with them multiple times, and then when and if they come see us on a regular basis, we kind of go through that with them again and again.
All right. Well, if you're looking to start that estate planning process, or if you want to go back through some things that you've already put in place, want to get a second opinion, best place to start, alatsaslawfirm.com. That is a website. We're going to put the podcast up there. There's some other resources to help guide you through your estate plan. But you can also call Ted and his team at 718-233-2903. Beneficiary is so important. But again, it's just one piece of that overall estate plan. So hopefully this helps you out today on this episode. But again, reach out to Ted if you have further questions. As always, Ted, we appreciate your time and look forward to doing it again soon.
Thank you, Ben. Same here.
All right.